Good afternoon, everyone. Thank you so much for joining our latest webinar, Legislative Updates, and which will go over recent legislation. My name is Natasha Dunker. I'm Communications Director for PERAC. Again, thank you for joining us. Any board members who are attending this live session, you will automatically receive 3 educational credits. It will be posted to your account in approximately 1 week. We will also be recording this session and posting it to the website at a later date. So anyone who's not able to attend today's session but views the recording can also get 3 credits by submitting a training affidavit in Prosper. The questions, we will have questions available during this session. Please open up your Q&A and submit your questions that way, and Patrick will read off the questions as time allows. The handout was emailed to you. A link to the handout was emailed to you, but if you did not get a chance to download it, I will post a link to that in the chat. And with that, I will turn it over to Patrick Charles, our Deputy Director. Thanks, Patrick.
Good morning, everyone. As Natasha mentioned, I'm going to be covering the recent legislative updates. This is very similar to the presentation that was done on emerging issues. So if you were there, you will have seen a lot of this. We have a little bit more information. As I had mentioned at that point, we were still working on 2 of the acts and how to implement them, the return to service section that we'll talk about in a few minutes, and also the Violent Act Injury Bill. And we're getting ready to issue memos on those probably early next week. It's possible they might go out late this week, but most likely early next week. So what are the topics that we're going to cover today? There are 5 basic topics we're going to cover today. The first one is going to be Chapter 141 of the Acts of 2024. This is an act relative to salary range transparency, and it has 2 components, one of which is an anti-spiking element dealing with systemic wage adjustments and wage adjustments that were done pursuant to MEPA, the Mass Equal Pay Act. And the second one has to do with post-retirement earnings and clarifying language in the statute, Section 91, regarding how much an employee can earn after they retire and what salary they base their earnings capacity upon. The second thing that we'll cover is Chapter 140 of the Acts of 2024, which is the fiscal 25 budget. And there were return to service changes there. That's the situation where a member goes out on disability and gets reevaluated periodically to see if they are physically or mentally capable of returning to employment. There were some changes to that we'll cover. As I mentioned, the Violent Act Injury Bill, that's Chapter 149 of the Acts of 2024, an act relative to disability pensions and critical incident stress management for violent crimes. This provides a 100% disability to certain public employees who meet the requirements of the Violent Act Injury definition. And I'll cover all of that and who's going to be eligible, who won't be eligible, go over a couple of scenarios for that. And then the last thing is Chapter 178 of the Acts of 2024, an act honoring, empowering, and recognizing our service members and veterans. This is the HERO Act. It's commonly referred to as the HERO Act. There is a separate webinar that was done in August that is available on our website, and you can watch that. It's a much longer explanation of all of the HERO Act and veterans buyback changes. It's about an hour long, I think. So I won't be covering every aspect that was covered in that today because we have the other 4 areas to cover. The first thing we want to talk about is the Salary Transparency Act with regard to anti-spiking. So anti-spiking is contained in General Law, Chapter 32, Section 5(2)(f), and this is the situation where you look at the salary, and if it goes up by 10% over a 2-year period, that there's a spiking issue and the regular comp has to be reduced and the calculation has to be recalculated. There are a number of exceptions in 5(2)(f), and one of them has always been if your salary is set by collective bargaining agreement. And one of the things that we found, though, going forward over the last couple of years is that there was an issue with MEPA, the Mass Equal Pay Act. And individuals were getting pay raises because it was determined that based on a gender equity study that a group of people were being paid less than their counterparts and they were getting raises. And sometimes those could be 10, 15, 20% raises. And then they were going to retire during the 3-year period. that their salary would be calculated upon. And we were unfortunately forced to tell them the statute says that if you get a pay raise of a certain amount, and it doesn't meet any of these exceptions, we have to reduce your benefit. And so these people were underpaid, being told that they were underpaid for a specific reason and had their salaries adjusted, and then their pensions were then being impacted. And so the new language adds for a bona fide increase in salary related to eliminating wage differentials as required pursuant to section 105A of chapter 149. That's the MEPA law. Or, and this is something the legislature added, from an employer systemic wage adjustment. So an increase in salary done following a MEPA study will no longer trigger anti-spiking. And so that's a pretty straightforward thing, that if the employer does a MEPA study, you question the salary and why there was an increase. And the employer comes back and says, we did a MEPA study, the salaries had to be raised because of it. It's an exemption. That's pretty much the end of your anti-spiking inquiry. The employer systemic wage adjustments is a little bit different, because this is not necessarily due to a wage study under MEPA. This could simply be that the employer increased salaries across an employer or a segment of the employer for whatever reason they want it. They could have just determined that, in order to keep this whole unit together, we need to increase the salaries. And so that would also be not subject to spiking, and it would be an exemption to anti-spiking. And the important thing here is the effective date of this is July 1st, 2018 for both of these changes. Why is that important? Because July 1st, 2018 is when the MEPA law went into effect. And so anything done after that, if there was any anti-spiking because of a salary increase that may have been MEPA or anything, they're wrapping this backwards so that those would be exempt now, and some recalculations may be needed to do. So we issued a memo 21 of 2024, and we list out a bunch of steps that boards need to take. In particular, we want to make sure that all the retired members of the system who add anti-spiking provision of section 52F apply to their allowance on or after July 1st, 2018, that they are rechecked to make sure that they are still subject to anti-spiking. Some of them will be, because not every salary adjustment that was done over the last 6 years was because of MEPA or because of a systemic wage adjustment. We often see people who simply got a 10% raise one year and a 10% raise the next year, and they retired a year later. Determine whether any of the received salary was pursuant to MEPA or a systemic wage adjustment. If it was, then you're going to recalculate and remove the downward adjustment for spiking. After adjusting the allowance, the board must refund to the member the underpayment amount of their allowance plus correction of errors interest rate. Now, on this point, one of the questions that we have received since we issued our memo is, why are we paying corrections of interest rate if the board didn't make an error when they did the original calculation? And that is true. The board did not make an error. The board did everything correctly according to the statute. But because the legislature has retroactively applied this to July 1st, 2018, they have essentially made any calculation done an error, even though at the time it was done, it was not an error. It's a convoluted system in a way, but that's why the correction of errors interest applies, because though there wasn't an error when you did the calculation in, say, July of 2020, the legislature has now determined it was an error, and so we have to correct it and use correction of errors interest rate. You can offset the lump sum payment to be made to the member by the amount of any contributions that were returned to the member when anti-spiking was applied. Now, the second aspect of the Salary Transparency Act dealt with post-retirement earnings. And this is an amendment to the salary that's used when calculating retiree earnings pursuant to section 91(b). PERAC has long held that you could use the salary from the position from which you're retired or the salary upon which your pension was based in order to calculate your post-retirement earnings, whichever was the greater salary. The issue here can be what the statute says, it's the salary being paid for the position from which the member retired. Well, if you were a 35-year employee getting the top pay rate for that job, and you are then replaced by someone who gets less money than, who's going to be paid less than you, what that would mean under that definition is that your earnings capacity has to use that new employee's salary. So if you were making 100,000, but the replacement employee was only making 90, you have to use 90 in the calculation of your post-retirement earnings, which artificially reduces your earnings capacity. And PARIC had always maintained that you would use the salary upon which your pension was based, because that would allow you to have earnings. Because we have in fact seen situations where someone retires and their replacement makes significantly less than they do. And in fact, that negates all earnings capacity. And obviously the legislature, in putting 91 little b into the statute, is acknowledging that an earnings capacity should be had by pretty much everyone who retires. They are just simply restricting the amount and the length of service you can provide in terms of hours. So there was a Dixon versus Lynn retirement system case at Crabb, and this was a situation where the gentleman in question had a higher paying job in the middle of his career, lost that job because the job was eliminated, wanted to get more creditable service to get to his 80%. And so he took a much lower paying job to do his last years of creditable service. And when he retired, the board applied the salary from the position for which the member retired, which was significantly lower than what his pension was based upon. Roughly, his pension was based upon a $90,000 salary, but he was only earning $20,000 a year in his final few years of work. So he had a 0% zero earnings capacity, and he was in fact found to owe around $50,000 because he had over earned for a couple of years. Even though when he retired, when he went back to work, he was still only earning less than $20,000, but it added up over the 3 or so years that he was doing it. So we went to the legislature and asked that some amendments be made to the statute to correct this, because we felt that preserving an earnings capacity was important, especially since the legislative intent has been clearly established to allow earnings capacity. Because over the last decade or so, maybe 15 years, you've seen an increase in the hours and limitations from 960 to 1200. The legislature has increased the salary by allowing an extra $15,000. And so they've obviously intended for people to be able to work. So we asked the legislature to correct this. And that's why they now use either the salary from the position for which the member retired or the salary upon which the retirement allowance is based. What does the salary upon which a retirement allowance is based mean? Essentially, if you take a look at that person's retirement calculation sheet and you see what the option A amount was, what salary was used to calculate his option A, that's the salary that upon which the retirement allowance is based, and that's the salary that they can use to determine their post-retirement earnings. The next section has to do with the return to service provisions, and this was found in the budget. And this is talking about section 8 of chapter 32. Whenever a member is retired for disability, they have to be evaluated periodically. I believe it's once every year for the first 2 years, and then it's every 3 years thereafter. They're evaluated by our doctors to determine whether or not they can return to their former position. It's the requirement under section 8. It's a statutory requirement. And if previously, a member had to be able to return to the position that they retired from or a similar position with the same employer. So this is very limiting in who can go back to work. And even if they are cleared medically, there may not be a job for them. We've seen a number of situations over the years where a person was able to return to work. Our doctors had cleared them throughout the whole medical process. They reviewed their medical records. They'd done an in-person review. They had 3 unanimous medical panelists say, yes, they can return to their job. But they had a job in which there was only one of those positions in the town. And that position was obviously filled during the period they were on disability. And so there was no job for them to return to. And so they could sit for years on the return to service wait list, hoping for a position to open up. The legislature saw this and they took action to change section 8 to allow a member who's retired for disability to be cleared to return to service with their original position, with the original employer or with a different employer. So if you're a water treatment operator in town X and there's no job for you there, but you were able to return to work, you can go to town Y and work as a water operator. Same job, just a different employer, no different evaluation needed. If you're returned for one, it would carry out as long as the job description for the two are equal, you would be able to go to that second employer. The other component that was added here is completely new and something that has never existed before in Section 8. And this is that a member may request that they be evaluated for a completely different position. And that different position could be with the same employer or with a different employer, even if that different employer is in a separate retirement system. So for instance, I use the example of a police officer who is no longer physically able to do the police work, but they have a law degree. They're licensed to practice law in Massachusetts, and there's a town council position open or a position with a state agency as a lawyer. They could ask to be evaluated for that position, which does not have, believe me, lawyers do not have the physical component requirement of their job duties as police officers or firemen. So they might very well be capable of doing that job, but not actually perform the physical aspects of their police work job. So they could ask to be evaluated for that position. And then we would determine whether or not they were physically able. And how we do that is the member must provide us with a new job description for that job, that new position. And it has to show the essential duties of that position, just the same as when someone retires for disability, we need to see their job duties. What are the essential duties of the job so that our medical panels can evaluate whether this person is physically and mentally capable of returning to work in that position. So you go through the same return to service examination process, only our doctors will be looking at your original job duties to see if you can return to that position. But we can also, if you request this, if the member requests this, they can be evaluated for a second position. And I can't stress this enough. This is something that the member must request. This is not something that an employer can require, that a retirement board can require. It's the secondary evaluation for a new position must be at the request of the member. And so if you're found able to return to the same position, you go through the regular RTS process as it's always happened in the past. If you're found able to go to a different position with the same employer, then you can be returned to the same retirement system like before and receive credible service for all the time they were receiving disability. Now, if you're able to go to a new position and it's with a different employer, this may be in a new retirement system. The same process that happens currently for someone returning to the same employer with the same retirement system will happen with regards to creditable service. The member is going to be given creditable service by the first system from which they had retired for disability for the entire period that that disability was collected. They will then become a new member in service of the second system. That second system will then have to be responsible for any creditable service that accrues from the date that they join that system until they eventually retire. So if the member is fortunate enough to return to work at a different system and then go out on superannuation, liability will be the same as it's always is for a member who has service in 2 or more systems. 3.8C will apply. The liability for the first system will be all the period that they worked in the first system plus any disability time. The second system, it will be any time that they have worked since returning from disability in that second system. So on down the line to if you can be transferred to a third system and have 2 3.8Cs, that's fine. It's the same process as a normal 3.8C. If the member returns to a second system and then goes out on disability based on the original injury, the first system will be assessed a portion of the liability under Section 7.5 of Chapter 32. And that liability will be, so the retirement will actually be from the second system then, but there'll be some apportionment of the liability, even though the disability may have, the injury may have occurred in the first system or the underlying condition occurred in the first system. The next statute is Chapter 149 of the Acts of 2024. This is the Violent Act Injury Disability Bill. And we're going to commonly refer to it as the Violent Act Injury Bill because the title of it is extremely long. And the majority of it is referencing this violent act injury. That is the key focal point for determining the eligibility of an individual under this provision. It amends Section 7 to provide a 100% disability to police, firefighters, EMTs, and some licensed medical professionals. I forgot to put those on this slide. it's 100% if they are disabled as a result of a violent act injury. And the statute provides this definition. And I don't like to read definitions too often, but this one is very complex, and it's going to be, the wording is very important for the underlying determination of whether someone is eligible. Violent act injury is a catastrophic, life-threatening, or life-altering and permanent bodily injury sustained as a direct and proximate result of a violent attack upon a person by means of a dangerous weapon which is designed for the purpose of causing serious injury or death, including, but not limited to, a firearm, knife, automobile, or explosive device. So as I mentioned, this is 100% disability benefit. Unlike traditional Section 7 benefits, in which you get a 72% disability plus an annuity factor, and if you're hired after the late 1980s, you're capped at 75%. This is a 100% benefit. And it's only available for people, again, I'm going to keep stressing this, who have catastrophic, life-threatening, or life-altering permanent bodily injuries. It must be a physical injury. The statute does not permit for emotional or psychological injuries to be eligible for the 100% benefit. This is because they have amended the standard to determine if someone is disabled under the 100% provision, under the Violent Act injury. It must be physically incapable of doing the essential duties of the member's position. And as I mentioned, the injury must be the result of a violent attack upon the member by means of a dangerous weapon. The dangerous weapon issue is one of the definition issues that is going to probably be the most problematic, burdensome, because it's not just a weapon. It has to be a dangerous weapon that was designed for the purpose of causing injury or death. And they list out these firearm, knife, automobile, explosive device. Those are obviously not the only dangerous weapons in the world, but it really does limit it, because anything that is used in the attack could be considered by many people to be a dangerous weapon. But the statute does not contemplate it unless the implement used, the weapon used, was actually designed for the purpose of causing serious injury or death. So what does that mean in terms of what are some examples? If someone is physically assaulted by another person with no weapon involved, and they suffer severe grievous injuries, they're not covered by this because they were not attacked by a dangerous weapon. So if someone injures you by pushing you down the stairs or kicking you or punching you, there's no weapon involved other than the person's body, which is not considered a dangerous weapon under this definition of being designed for the purpose of causing injury or death. So those are some examples where, though you may have grievous injuries that might be catastrophic, life-threatening, or life-altering, it has to meet the other criteria as well, and being a violent attack with the means of a dangerous weapon. Other items, there are other household items that might be grabbed in the heat of the moment when a police officer breaks down a door or chasing a suspect. They may grab an implement off the street. But again, if that is not a dangerous weapon designed for the purpose of causing serious injury or death, it's not going to qualify under this statute. It's 100% disability. How is that 100% disability calculated? It's 100% of their regular compensation, including all benefits and stipends that the member was earning on the date of the Violent Act injury, as long as those benefits and stipends were pensionable. So things like longevity would be included. If you had a hazmat stipend that was regular comp, that would be included. Their shift differential would be included because that was an includable, pensionable amount in your, while you were working. It would continue going forward. And it would be, this 100% disability is similar to a Section 100 benefit, with the exception that the member is still alive, obviously, under this Section 7 disability. But the calculation is basically the same. You're getting 100%, and it's going to be adjusted anytime the salary for that position is adjusted. So that could be annually, if it's an annual collective bargaining agreement raise, or if the position is raised on an annual basis. But anytime the salary is increased for the active member holding that position, the disability allowance will be increased as well. Mandatory retirement age. If a member will receive 80% of the annual rate of compensation paid in the previous 12 months when they reach a mandatory retirement age. So this means you take whatever the 100% benefit was that they received in the previous 12 months when they turned 65, you go calculate that and reduce it to 80%. going forward. Now, some of the people listed in the eligibility for the Violent Act injury, police, fire, they're subject to mandatory retirement age of 65. Other members that may be eligible for this benefit are not subject to a mandatory retirement age, so their benefit will not reduce to 80%. It will stay at 100% going forward and will be calculated annually as if they were continuing to work. One of the other benefits of this act is as soon as someone is approved for the 100% under the Violent Act injury, they will receive a return of their total accumulated retirement deductions. Similar to what happens in a Section 9, if there's any deductions left that's returned, this is returned while the member is alive to the member. If the member is married, the spouse will receive 75% of the member's pension upon the death of the member. This 75%, if the member dies while they're under the maximum age or while they're still receiving 100% benefit, the spouse will receive 75% of that. If it's an 80% because the member's already been retired at the mandatory, the member has already reached the mandatory retirement age, then their benefit would be 75% of that 80%. It's always going to be 75% of whatever the member was receiving at the time of death. There are also provisions to provide for the children if they are underage or incapacitated from earnings, much like some of the other benefits in Chapter 32. The child will get those benefits if the member and the spouse are predeceased them. Then the children, if they are incapacitated or if they're underage, will get the benefit. It will be split among the eligible children. One thing is that the total amount is split equally. So if there's 3 children, each one would get a certain percentage. And when one of those either ages out or is no longer incapacitated, whatever the case may be, and they're no longer eligible for the benefit, the other 2 continue to receive the same amount. It does not get reapportioned to a higher amount to account for there being only 2 beneficiaries rather than 3. There are also some changes to the post-retirement disability earnings limitations for people that are approved for the Violent Act injury benefit under Section 7. As you know, currently members who go out on disability are subject to 91A earnings limitations, which is a dollar amount limit. And they're also subject to 91 little b earnings restrictions if they are working in the public sector. Here, the legislature has exempted disability retirees under this Section 7 Enhanced Violent Act Injury Disability. They've exempted them from those earnings restrictions, and they have created new earnings restrictions for them. And if a member goes back to work in the public sector, they can earn 50% of their retirement allowance, as long as they are not going back to work in a Group 3 or Group 4 position. But they are allowed 50% from the public sector. But if they go to work in the private sector, which under normal 91A rules, you would still be subject to earnings restrictions, those earnings restrictions are lifted. And if you work in the private sector while receiving this Violent Act injury disability, you have unlimited earnings and there's no hours or any tracking of your earnings at that point if you're only working in the private sector. The next act is Chapter 178 of the Acts of 2024, which is the HERO Act. This is your veterans buyback. And as I said, there is about a 1 hour, 1.5 hour webinar that is available on our website that you can watch to get a little bit more information. And there's also a Q&A handout. We responded to the Q&A in writing and posted that on our website as well. So there'll be a number of questions that may be answered if you just take a look at that. But I'm going to go over the basic provisions and not quite in the same amount of detail. So what has not changed? The definition of veteran in Chapter 4, Section 7, Clause 43 has not changed. This is important because if you actually look through the HERO Act, there are a couple of places where they have amended the definition of veteran in other sections of the law that deal with different veterans benefits, non-public employee veteran benefits, but those changes did not have any impact on the retirement system because the definition that we use for purposes of veteran under Chapter 32 is contained in the Clause 43 and has very specific provisions. There's no change to the amount of time that can be purchased. You can still purchase 4 years of prior military service. This can be a combination of National Guard and Reserve time at a 5-to-1 ratio, or it could just be someone joined the Army at 18, got out at 22, became a police officer, teacher, whatever. They had 4 years of military service prior to their ever being a public employee. There is going to be some overlap, which I'll mention, between you could have some prior service, but then you may still accrue more service because you're in the reserves or the Guard while you're a public employee. The amount that you have to pay to purchase each year of service has also not changed. It is 10% of the regular compensation when the member most recently established membership in the system. We've gotten some questions about what does this most recently established membership mean? If a member joins the system and does not purchase their military time, and after 3 or 4 years, they leave the system and withdraw their money, and then 5 years later, they come back into the system and they redeposit and rejoin the active service in the system, it's the second system or the second employment, the salary that you use, because as soon as someone withdraws their money, they sever all ties and all rights to any benefits under Chapter 32. And so they no longer can use their first year salary. They have to use the most recent entered system. But if someone simply transfers from one system to another, they work 4 years in one, then they transfer the second system, no withdrawal, even if there's a break in service, but there's no withdrawal, you still use the first year's salary, and you'll have to get salary information from that, even if they are in a separate system now with a totally different job. There's also still the 5-to-1 ratio for National Guard and active reserve time. The key to this provision is you must qualify as a veteran to be eligible. I have told this story in every veterans training I have given, but I have seen members who had 20 years in the National Guard and who did not qualify as a veteran under the statute because they did not have enough active duty time. They only had active duty for their weekend a month, their 2 weeks a year, their initial active duty training for boot camp, but that does not qualify them unless you have the necessary 90 days, one of which is wartime, or 180 days of active service, regardless of wartime status. And that's brings us to the next point, which is that active duty for training for the National Guard and Reserves is excluded. National Guard training and reserve training does not qualify you as a veteran. It is also not considered active duty for purposes of buying time at a 1-to-1 ratio. So if someone is in the National Guard and they get activated for, say, 15 months prior to ever becoming a public employee, they get active duty. Maybe there's, you'll see this a lot. People may have been sent over to Iraq or Kuwait, Afghanistan for 15 months on the National Guard or as a reservist. When they come back and when they join your system, that 15 months is active duty under the national authority, and they are eligible to buy that 15 months straight as if it was regular Army or regular Navy, regular Air Force time. That is not true for the active duty where they are on full-time active duty for the 6 months of their boot camp. That does not ever become day-for-day purchasable. It's just simply added to and calculated in the total Guard and Reserve time when you do the 5-to-1 ratio. The other thing is active duty lead time cannot be counted towards a buyback. So this is the situation where you are in the reserves or the Guard, you're a public employee, 3 years into your public employment, you get called to active duty with the Guard or reserves, you spend a year away, and then you come back to employment. When you come back to employment under 41H and Chapter 32, you get credible service for that year that you were deployed or that you were on active duty. Then when you go to purchase your military service at the 5-to-1 ratio, you qualify as a veteran, yes, and you can do it. And maybe you have 15 years in the Guard total. But if you were activated for that 1 year, you have to subtract that 1 year from the calculation of the 5-to-1 ratio because you've already gotten credible service for that time. The other key provision here for all veteran benefits like this, purchase time, is that you must be a member in service. Retirees are not eligible. Members inactive are not eligible to make the buyback for military service. So what changes do we have to the veterans buyback? This rewrites Section 41H. One of the biggest changes to this act is it eliminates the 180-day purchase requirement from Chapter 71 of the Acts of 1996. This 180-day provision has always been very confusing for people because it is not and was never in Chapter 32. It was always simply a component of Chapter 71 of the Acts of 1996, which was the act that originally included the paragraph concerning the buyback of prior military time under 41H. And so people didn't know where it was, didn't understand what it meant. Basically, the requirement was that a person had to be given notice of their eligibility, and they had 180 days to decide whether they wanted to buy their time. And they either had to, depending on how the system handled it, they either had to make payment within 180 days, make arrangements for payment, or simply acknowledge that they had time that they may in the future purchase. It was treated differently from board to board, and that caused a lot of inequity from system to system, frankly. And one of the reasons why the HERO Act, these changes were pushed at the legislature. 180-day does not matter anymore. You can pretend it never existed as soon as all of the people that were exempted from it are corrected under this one-time option that I'll go over in a minute. But essentially, the 180 days is gone. Does not matter anymore. The other requirement that it was never in 41H before is that this now requires that boards give notice of potential benefits to all new employees. So I've suggested in our memo to the boards, we suggest that as soon as someone signs up for the system and fills out their new member enrollment forms, you hand them the explanation and the buyback form for veterans benefits so that they are aware that they are eligible, and it has been updated to show new eligibility, new payment requirements for when the payments must be made. The other change, since we've eliminated the 180-day issue, now it provides that the purchase of the service must be made within 1 year of vesting, which essentially is 11 years of creditable service. One of the questions that we have gotten repeatedly, is it just 11 years? Or is it 11 years of actually working? It is 11 years of creditable service. So that includes anything that was purchased in some other purchase. Maybe it was prior non-membership time that you may have purchased when you became a full member. Anything that counts towards creditable service, you have to calculate the 11-year from that. So it may only be 6 or 7 years of actually being a member of the system that will get you the 11 years of creditable service. I'll go into this in a little more detail in a minute, but National Guard and Reserves, because of the nature of their service and the fact that they accrue service differently, they have a different purchase window. And the last bullet point here, new 1 year window for anyone who missed purchasing their service. This is all of those people that either missed the opportunity to purchase because they were told they were ineligible because they hadn't done so within the 180-day window, or they simply just didn't have the money and decided they weren't even going to ask about buying it back because they couldn't do it at the time. So either way, no matter what, anyone that is a veteran who has not made their purchase gets a new 1 year window to purchase their service, regardless of the reason for why they have not purchased it prior. On this slide, you'll just see highlighted all of the amendments to Chapter 32, Section 418, the 4th paragraph, which is the veterans buyback paragraph. I'm not going to go over those. You can look at those just to see exactly where we're getting some of these concepts from. So as I said, there's no 180-day window. You now have 1 year of vesting in the system. Vesting is 10 years of creditable service, and that applies to every group. I know that there is a provision in Section 5 that allows a Group 4 member who is over age 55 with less than 10 years of service to receive a retirement allowance. That is not a vesting issue for them. That is simply a provision in Section 5. The vesting under Chapter 32 is 10 years. And so it's effectively 11 years of creditable service to decide whether you want to purchase your military service. So National Guard and Reserves, just like everyone else, they can purchase up to 4 years of time. However, National Guard and Reservists accrue time slightly differently sometimes because, as I mentioned before, you could have someone that 18-year-old that joins the Army right out of high school, stays in until 22, then gets a public employee job after serving 4 full years. They're a very easy situation. They get to buy 4 years if they want to, because they had 4 years prior to becoming a member. With National Guard and Reservists, oftentimes what we see is someone either spent some time in the what I'll call the regular military, the full-time military, but not 4 years. Then they were transferred to the reserves or the Guard, and they served many years after that. But they may have become a public employee while they were a National Guardist or reservist, and they didn't have enough time to get the 4-year purchase. So those people will have a different amount, a different calculation of when they can buy their time. But the other situation that we often see is someone who joins the National Guard and Reserves doesn't get activated and thus doesn't qualify as a veteran until sometime while they are a public employee. So you may be in the Guard for 3 or 4 years and a public employee at the same time, completely overlapping, but until you get activated, you're not considered a veteran. So now they get deployed for, let's just say, a year for ease. They get deployed for a year, they come back, they keep working. Well, now they're counted as a veteran. They've got that 1 year of credit automatically, so we can subtract that from their total. But they're still going to need to work and be in the Guard and Reserves for a number of years before they're ever going to get the 5-to-1 ratio to be equal to 4 years. So that's a 20-year term in either one. So they're going to get a different amount of time. So here's how they do it for National Guard and Reserves. If you don't qualify as a veteran by the time they reach within 1 year of vesting, or if you're not eligible for the full 4-year buyback, you're given additional time. You are given the later of 2 dates, 5 years from when they qualify as a veteran, or 5 years from the date that they qualify for the full 4 years of purchase. So you may have someone that's in the system for over 20 years before they are even, before their 5-year window even starts. That is entirely possible. You could also have a shorter period because you may have where they had 2 years of prior military time in the full-time military, and then they spent 10 years in the reserves. So you may be a shorter distance, but it will still be 5 years out from that latter of the 2 dates. How does this 1 year grace period apply? Members who missed the opportunity to purchase their military service will have a 1 year window. So this is from August 8th, 2024 is when the act was effective. And so they have 1 year from that date to make arrangements with their board for their purchase. So they have until August 8th, 2025. So here's what members need to do. If the members already purchased their military service, they don't need to do anything. So any notice that you send them, they don't need to do anything with it. They're all set. They've made their purchase. Here's where you get into a couple of issues that we've had. Members have more than 11 years of creditable service. So they're already past the new time frame that would be allowed for the purchase. So they have to come in. If they haven't done their buyback, they have to come in by August 8th, 2025 and enter into a purchase agreement with the board. This could be a lump sum or an installment plan, depending on board policy. Now, we have said in our memo, and we have sort of said at some of these trainings, that some of these lump sum amounts could be fairly substantial if you're purchasing 4 years of service. And so we encourage boards to offer installment plans. It is up to the board policy. I have gotten a number of questions on installment plans. And one of the questions that we get is, I've gotten a number of boards say, my board doesn't offer installment plans for any buyback. Can we do it just for veterans? Or if we allow veterans, do we then have to allow everyone to do buybacks under an installment plan? The answer is yes. You can do an installment plan policy solely based on veterans' time. And I've seen a couple of boards who have been in this situation. They've sent in supplemental regulations to us to review and to approve that says, for veterans buybacks only, we will allow a 3-year or a 5-year installment policy. But again, this is a board policy, but we would encourage installments because we have seen a number of situations where members may owe $30,000, $40,000 to purchase 4 years. And we understand that some systems allowed people to simply sign the form and say, yeah, I'm going to buy this sometime before I retire. And now the legislature has changed the goalpost. They have said, no, you need to do it within 11 years or within 1 year. If you're past that already, you need to do it within 1 year. And to come up with that $30,000, $40,000 by August 8th, 2025 may be an impossible burden for some. However, I would also tell everyone and make sure that the members are aware they can do these buybacks through a rollover. So if they have an IRA, they have a 401k, they have the 457 smart plan, they can do a rollover for that without tax consequences. And you can make the payment through that. Now, if the member has less than 11 years of service, they have until one of the two dates. Either they reach 11 years of service or August 8th, 2025, whichever is the later of the two. So if someone's only at 8 years right now, they're going to have another 3 years before they have to enter into this installment agreement or make the lump sum purchase. But if they are already at 10 years, it's going to really depend on where that 11th year falls, whether it's before or after August 8th, 2025. So here is what I was just talking about, what members need to do if they haven't completed the purchase and they're outside of the window. They need to complete the purchase or enter into the installment plan before either the end of their 11th year or August 8th, 2025, whichever last occurred. And again, we encourage boards to do installment plans. And if you have any questions about installment plans or allowing it or what regs look like, if you want to do a specific reg just for veterans buybacks to be allowed to be made that way, please contact me and I can give you some examples and walk you through that. Now, what do boards need to do? And I know many of you have already done this. I already got my letter from the state board, but the deadline is coming up very close soon. Every board must send a member to all active members of the retirement system, informing them that they may be eligible for military service buyback. We provided a sample notice in memo 23. And so you can tweak that and use that to be specific. You might want to put in something in the bottom there about whether it's a lump sum payment, an installment plan, contacting the retirement board, but you must send that notice to all members by November 6th, 2024. You should also be notifying any member who you have who's previously completed the application, but who has not made arrangement for the payment, to make sure that they do so by the new deadlines, which again is the later of either 11th year of credible service or August 8th, 2025, if someone has already passed that 11 years. You should also review your board regs and see if there's anything veterans buyback. I know some boards have veterans buyback regs that will talk about the 180 days, that the purchase must be made in 180 days. Those regs are obviously no longer valid because that is not a requirement of the statute any longer. So you may want to look at either updating that reg or just repealing it and notifying us so that we can approve the new reg or remove the reg from our website. And you should also begin using the updated notice of potential benefits forms on our website. I highlight this again, the notice issue. You must give notice to every new member when they enroll in the system. And you also need to send out that notice by November 6th, 2024 to every active employee in the system and start using the new forms. A good point is to have it be part of the new member enrollment packet, the new form, and just because that has a summary of the benefits. And then the second page, I believe it's just the second page, is the actual application. So just give them that packet so they're aware that it's part of the benefits that they may be eligible for. I realize that a large number of employees are not veterans, so they are never going to be eligible for this benefit. But the fact is, we don't know who is a veteran when they start public employment. Even they may not acknowledge that they're a veteran. They may not check off any boxes or notify you that they're a veteran. But also some people, like we talked about with the National Guard and Reserve, they may not be classified as a veteran when they start in your system. Well, I've seen members that were in the system for 5-10 years before they even joined the reserves or the Guard. So they may never have qualified and not have been eligible, but by giving everyone notice, they will then know that if something changes or if they had not acknowledged it, that they may be eligible for a veterans benefit. Here's my contact information. If you have any questions about any of these acts, as I mentioned, we will be issuing, I believe next week, we'll be issuing a memo on the return to service process. The one thing I should have mentioned about the return to service process is that's one of these things that is going to be a lot of work for the member and for us to do these evaluations and to check the new job descriptions and so forth, but it's not really going to be something that the boards are involved in. The boards are not involved in the return to service process until you're notified that someone has joining the system because they have been returned to service. But the actual evaluation, getting all the medicals and everything, that is all the responsibility of the member and PERAC. So That's one good thing, but that memo will be out. And then the violent act injury, which will have some substantial requirements for the boards, that will be released next week as well, hopefully. I will go and take some questions now. As soon as I find them. Okay, there. Is MEPA a standardized evaluation? Would retirement office need to achieve some type of salary assessment? Is MEPA the same if a city or town calls it reorganization? Okay, so the first part of this question, does the is it a standardized evaluation? I don't know how a MEPA study is conducted. I don't know if it looks the same in every time one is done, but yes, the retirement, if there's a question about spiking and the board goes to the town and says, this person looks like they spike, why did their pay increase? And they say it was because of a MEPA study, then you should ask for part of that study that at least reflects why that person's salary or why that unit's salary was increased. A reorganization, that's a trickier question because it doesn't necessarily, if they just start changing everyone's job title and moving people from unit to unit and they get pay raises, that's not a systemic wage adjustment necessarily, but it could be a bona fide change in position. And so then you might have an exemption for spiking for that. Another question, traditionally, we've excluded raises pursuant to a salary study. Does the systemic wage adjustment language now allow that? I would think that yes, in some ways that would be if the salary study was done and it was done over a segment or over the entire employee population of an employer and changes were made, then yes, that seems to be a systemic wage adjustment. The systemic wage adjustment simply, it's very important to make sure that it's not just individual employees that are getting wages. It's not just that Bob Jones is a very valued employee and we don't want him to take a job in the next town over, so we're going to give him $10,000 more a year. It's, Bob Jones and 6 other people all are underpaid compared to the neighboring town, so we need to raise them all by 10,000. That would be a systemic wage adjustment. But if it's just to retain one employee, that's not a wage adjustment. That's an individualized wage adjustment. In a post-retirement earning, do I use the salaries being paid for the position now or what the member would be earning if he had not been retired? You use the salary for the position that is being paid for that position now. So if you have a sergeant with so many different stipends and so forth, and the highest step retires, then you take that same person that's currently working and use their salary. If that salary is lower than what the person's pension is based upon, then you use the salary that is used in the pension calculation. It's the greater of the two. So for return to service from, I just lost it. From return to service from page 6 of the handout, what would happen if the member's annuity account from the first system, benefits that have been paid while they were out on disability and COLAs throughout that time? There's nothing that happens. The member's account, if there's any money left in the account, gets transferred to the new system if they go back to a new system. Just like any other transfer, there's no recoupment of any annuity paid or recoupment of any COLAs or anything that were paid as part of the disability. It's just person gets credible service, does not owe anything, either comes back to that same system or goes to a second system and transfer just like a normal one. Who makes the determination what is catastrophic? The board, PERAC, the member's attorney? Ultimately, the board has to make a determination whether this member is going to qualify under the Violent Act Injury Bill. And they have to determine whether a catastrophic, life-threatening, or life-altering injury occurred. Now, our medical panel will be instructed to review that as well. And so you'll get evidence from the medical panel. But as with all disabilities, the board is going to be responsible for making the determination as to whether someone qualifies based on the medical evidence, the medical panel information that they receive, any other information that they get through a hearing, medical records, reviews. And one of the things that we will point out in our memo is that boards are going to be required to do findings of fact for any time they approve a violent act injury. And those findings of fact are going to have to show that the member that the member was in suffered a catastrophic, life-threatening, life-altering injury, that there was a violent assault with a dangerous weapon, what the dangerous weapon was, excuse me, why something qualifies as a dangerous weapon. And this is going to be key when you start looking at items that are not specifically listed, like a knife is listed, but what about some other implement, or an automobile? In that case, you're going to have to show that not only was the member struck by an automobile, but that it was intentional. If someone is just rear-ended in an accident, a negligent accident, that is not an intentional assault on that person, even though it may qualify as an assault under certain definitions, but it does not under this statute. And this is all going to be laid out in more detail in the memo. But it's going to be the board that has to make all these determinations, and it's going to be the board based on all the available evidence and the evidence that our medical panel provides as well in terms of our narrative. It will be a slightly different report than a simple, straight, regular disability application.
Hey, Patrick, it's Bill. Just to add on to what you're saying, I think we might just want to let people know that we want to engage in a regulatory process around this, have hearings, let people be heard, everybody can weigh in, and we can try to come to a better definition of some of these terms.
Right. We will go through a regulatory process at some point in the future. If a police officer is attempting to subdue a suspect and the suspect strikes the officer over the head with a large stone, which is also in the officer's death, he doesn't qualify for the 100%. Well, two things here. One, he probably is going to qualify for 100%, but it's not going to be under Section 7 violent act disability because the officer has died. So he will qualify under a Section 100. And that is 100% benefit. And say the member doesn't die, it's a very strong question as to whether this would be, he'd be eligible for this, because the large stone is not a dangerous weapon designed with the purpose of killing or causing injury or death. If the member is still receiving 100% when they pass away and then the spouse gets 75 of that, will it go down once the member would have turned retirement age, or will it always stay the same? I have to look that up because I think that it reduces, but I have to make sure before I answer that. Shoot me an email with that and I can answer it, but I think it's addressed in our memo, but I don't remember exactly how we phrase that. If a board doesn't make a new member aware of their veterans time and the member transfers to another system, does the first board take the liability if they can't show proof that the new member is aware of the veterans time? No. Do National Guard members who qualify as veterans have DD-214s or something else showing the service? So if a National Guard member is going to qualify as a veteran, they must have a DD-214 that shows that they have the required active duty time. Anytime they were activated that would qualify them as a veteran, meaning that they had to have 90 days of active duty, one of which is wartime, or 180 days of active duty, non-training time for both of those, they have to have a DD-214 to show that. Otherwise, they're not going to be classified as a veteran. They would also have, in the National Guard, they would have something called an NGB 22 form. That is a form that shows their total reserve time. So you may have one or two different DD-214s that show that they were active duty for a period of time over their, say, 20 years in the Guard. And then you'll see an NGB 22 form that will list, 20 years total service in the Guard. And it'll also have a category on there that'll say something like prior activation time, prior inactive duty, and there's a couple other categories, but it's all going to be on this NGB 22 form. The people in the Army Reserves, Navy Reserves, they'll have another form. I think it's a form 256, but some of the services have their own version of these forms that you can extrapolate from their dates on each year and the points that they receive as to whether or not they were in the reserves for that period, and that you can calculate how much total time they have. If a member is out on administrative leave, can they still purchase military time? It is unclear why the leave was imposed. However, it is likely behavioral. If they are still carried as a member in service in the system, then yes, they can make the purchase. I have a member who's exploring this, but his disability is not even close. Plus, he's been on disability for 15 years. No. A member cannot get this violent act injury unless they have not been approved for disability as of October 29th, 2024. So if someone was injured 6 months ago and haven't been approved for disability, and now your board is processing their application, they will be able to go for the 100% disability. If someone has got approved for disability 6 months ago and it would have qualified, they are not eligible to have their benefit recalculated. The eligibility for this goes forward to any benefit that is approved, which means approved by the board and approved by PERAC, a final approval by PERAC, after October 29th, 2024. Has PERAC ever considered seeking a remedy for the inequity whereby National Guard members get no credit at all if not on active duty, while a teenager working for the Newton Park Department for a summer job gets retirement credit for that? That is an inequity. We have not pushed anything and seen any, I have not seen any bills or anything that would change the definition of veteran to allow for this. This question did come up a number of years ago because I believe it was when President Obama was still in office. They changed the definition for federal benefits to include National Guard members who have 20 years of total time in the Guard, regardless of active duty time. But that was never a change that was adopted by the legislature. And so the statute has still been the same. So I don't know if there's any movement for that, or if there's anyone that's even proposed it. I've never seen it. Let's see. What if a member joined the system in 1995, left for several years, and then came back 6/22/2009? What annual salary should be used? This member left funds in the retirement system. If they did not withdraw their funds, you use the salary from when they joined the system in 1995. Yeah, I'm assuming this is talking about the purchase of veterans time. So anytime that there is money left on account or a transfer from system to system, you use the first system salary or the first salary. It's only if they withdraw, then they have severed their membership and severed their rights. And so they would then have the new salary being used. I'm not sure I understand this question. So the person who asked if a member retires and a few years later wants to return to work, wouldn't we use a salary for the same grade and step for that position rather than what's being paid to the person that currently holds the position? I'm not sure what that's in context. If you want to email me directly, I can try to respond to that. That seems to be most of the questions that I can answer today. Are there any other questions? Please let me know. Oh, see another one. How are we to research if someone were adjusted due to anti-spiking? So if you do a calculation and you do the anti-spiking calculation and you determine that there appears to be a spiking, because the salary increased over the last 3 years by X amount and it's triggering the 10% spiking, you should contact the employer to find out why that pay was increased to that level. And if they tell you it's from a MEPA study, then you ask for the MEPA study so that you can see that that's why the pay was increased. If they say you can ask them specifically, was there a systemic wage adjustment? Was this a one person salary adjustment? Or did you adjust everyone in a unit or something? You can ask them that and find out, get the information from that, get some payroll on that. They can point you to the members because you'll have member contributions from a number of people. If they're all in the same unit and they're all getting this, you can back into it essentially. Okay. Okay, so here's a question about looking at DD 214s. For vets that have more than one DD 214, will you take a look at them to be sure the proper service is being calculated? I am happy to help anyone who has a tricky question with DD 214s, but the boards can certainly certify that someone is a veteran. So for instance, if someone has a one DD 214 and it says that they have exactly 4 years of military service with the United States Army, you do not need to send that to PARAC for certification that that person is eligible for 4 years. The board is certainly capable and empowered to just announce that person has 4 years of military service. I understand that when you have a number of people who have National Guard reserve time, they have DD 214s, they have overlapping service, that could be an issue. They can be very tricky. And if you do try to figure out what it is, and you have a question about it, please contact me and I will help. But you know, a lot of these DD 214s are straightforward and PARAC does not need to certify it to anyone. The board can certainly do that. I have another question here about this National Guard issue. Did you say that active duty needs to be subtracted from National Guard time if they overlap? Okay, so when you do a calculation of how much time a person can purchase, and you're trying to determine the 5-to-1 ratio, now it's important to note that under normal situations and buybacks, and this is true for military buybacks where someone was in the military prior to joining the system, it's a pretty straightforward, they're not getting any credible service at all for any period of time that's associated with that military service. So in my example that I used, 18-year-old to 22-year-old is in the service and then joins the system at 22. None of that time overlaps with anything he's getting credible service for. So it's straight 4 years. You can buy 4 years. There's nothing. There's no overlapping. The issue with National Guard and reservists is that provision applies at a 5-to-1 ratio for anyone who is a former or present National Guard member. So that means that you can be accruing veterans buyback time while you are a public employee. So you start work on January 1st, 2024, and you join the National Guard on January 1st, 2024, you can work for the first 20 years and be accruing credit time at the 5-to-1 ratio that you will be able to purchase, assuming that you qualify as a veteran. So in a situation where a member is a public employee and gets activated, let's use the example where, okay, I start January 1st, 2024. On January 1st, 2025, I get activated for the entire year of 2025. On January 1st, 2026, I come back to work. The system will credit me for 1 year of creditable service for the time I was on military leave from my public employment, because you get military leave time if you leave public employment, go on active duty, and then return to public employment. You have to be given creditable service, and that's where the whole special military fund, the town has to make the contributions that would have been made, and that's all covered in a much longer veterans webinar. But you will get that credit. Now, 20 years later, when you leave the Guard and now you're ready to buy your 4 years because you think you've got your 20 years, what you have to do when calculating that total time to take the 5-to-1, you have to subtract out that time that they were a public employee who left for active duty, and when they came back, they got creditable service day for day for that time. So in my scenario, that year of 2025, I already got creditable service for it. So when you calculate my 5-to-1 ratio and I have exactly 20 years, I don't have exactly 20 years. I have 19 years. You have to subtract that out. And so you'll be slightly less than 4 years of purchase. Now, if someone has well over 20 years and they only have 1 or 2 activations and it's not, you're still going to get the 4-to-1 ratio, but the 5-to-1 ratio equaling 4 years, but you do have to subtract out any time that you've already gotten full credit for. What if someone was hired as a call firefighter then made permanent several years later? Do we use the annual salary as a call firefighter? If that person was made a member of your system as a call firefighter, then yes. If they were simply a call firefighter who was not a member of the retirement system and didn't get creditable service until they became a full-time member of the fire department, you'd use their full-time salary. But if they were made a member, and there are a few systems out there that make call firefighters members of the system, that is, you take their annual salary for that year of call firefighter time. Does enter into a payment plan necessarily mean that the first payment needs to be made by August 8th, 2025? If you have agreed to a payment plan and that payment plan is finalized by that date, then that's fine. But the payment should start as soon as possible after that. It can't be that you've entered into a payment plan on August 7th, but the payments don't start till December of the year. They have to start, the next monthly opportunity or the next pay opportunity, whatever the earliest that you could set up, especially if you're doing a payroll deduction or if however you're doing the payment. I'm not sure exactly how boards get the payment, whether it's through payroll deductions, whether it's always through a check by the member. I don't know that. So here's actually a question or a comment about DD 214s where there's someone says, if you have multiple, I would use the last one issued because block 12D on the 214 will show the aggregate of prior active service. That'll be added to the active service listed in block 12C. That is a good estimate, but you should have copies of every DD 214 and make sure that each one is complete and has the honorable or character of service being classified as honorable. But you also need to look to make sure that if the person's guard or reserve active duty, that it's not a training DD 214, because oftentimes you'll see guard and reservists who have 4 DD 214s, 3 of which are for active duty and 1 of which is active duty training, and you have to not use that in calculating the buyback until you use the 5-to-1. There's another question about going on leave, and I'm going to cheat here and pull up chapter 32 because I want to quick answer it because it's a good question. So the question is, if a member is a reserve and called up to military services and out for a year and then comes back to work, does he have to come back to the same board to earn that year of service, or will he lose it if he goes to a different board? 41H, the 3rd paragraph, describes what happens when you go on military leave and how you get credit when you come back. And it says that you don't get creditable service when employed in any governmental unit in a position which is subject to business section 1 to 28. So it can be in your former position or in a similar position or employed in any governmental unit. So you would get the credit regardless of where you rejoined. If someone starts with a new board with less than a year and came in as a transfer from another board with 3 years, do I use the first year of the prior board for the 10% vet buyback? Yes, you do. As long as the key word in your question was transfer. If it was a transfer, you always go back to that initial first year payment to determine. If a member is currently on military leave and is expected to come back in February 2025, not sure if the orders will get extended, is there any way to get additional time to purchase beyond August 8th, 2025? He has 4 years of eligible military service and 11 years of credit. The statute does not provide a mechanism for there to be an extension. So he's going to be subject to the August 8th, 2025 deadline to enter into the installment plan or the lump sum, depending on your board and what it is required, what requirements they have. On military buyback, if you're buying back, say, 4 years of service and one of those years was in a combat zone, does the member pay for that year deployed in a combat zone? If this is prior military service that predates your public employment, you pay for it just like any other year of buyback. If you are an active member of the system and you get activated and get sent to a combat zone, the payment for your creditable service for that year is done through the special military fund, and the employer is responsible for making the payment into the special military fund of what you would have contributed. However, there are some communities who, when someone gets activated, they pay either part or all of their public employee salary to them while they are also on leave. In those instances, that salary that you're being actually paid by your employer is treated just as a regular employee's salary and as if you were not gone on military leave, and contributions would come out of your pay for that. So if you're getting, some people get the difference between their military pay and their civilian pay, the employer pays that. Deductions would come out of that amount, and then the remainder of your salary that would have had deductions taken, the special military fund has to be credited with that by the employer when you return to public employment. Okay, that's all the questions that I see. If anyone has any further questions, you had my contact information on the last slide, and I believe that was sent to you also. And I think a number of you probably know who I am at this point, so feel free to email me or give me a call. I don't know if Bill is going to jump on or.
Trying to get my video up. There we go. Thank you, Patrick. That's a lot of work. Thank you for all your answers to the questions. Thank you to everybody for participating and all of your interest. We certainly understand the last couple months here, there's been a lot of legislative changes that have resulted in a lot of Chapter 32 changes, a lot of memos. We're certainly cognizant of that, and thank you for your work and your collaboration on this. I would just like to reiterate what Patrick mentioned earlier about the installment plans on the veterans buyback. Understanding the terms and the conditions of a buyback are ultimately the purview of boards. We would encourage it in those instances where an open-ended period had been allowed. It's certainly a unique circumstance. Somebody might think they have 20, 25, 30 years to make this payment, and now all of a sudden they're told they have to do it in a year. Certainly if they have a smart plan, a 401k, an IRA, what have you, they can do a rollover. Maybe there's savings. I guess worst case, somebody could try to do a loan. From what I understand, at least in the public safety world, there's a credit union, I think, that's putting together a potential loan program for something like this. There may be others that deal with public employees. If your board doesn't do installments as a rule, you could do a supplemental reg just for this unique circumstance. We had also heard a little bit about the logistical issues, the difficulties with doing installment plans. I just spoke with Patrick and John Borak on this yesterday. You don't have to worry about changing rates. Generally there's not an interest charge to a veterans buyback. Although I guess there's administrative law cases that say in an installment plan, regular interest can be charged, which has been 0.1% for a long time. But when that installment plan is set, it's the amount of money owed, if you're gonna include the 0.1% over however many months, and that's it. It doesn't need to change from that point going forward. So I hope that might take some, add some clarification. I'm not sure that, like I said, I had heard a little bit of scuttlebutt that there was some problems or logistical issues with doing it. This certainly could provide some hardship to people that the intent here is to let more veterans, as many veterans as possible, get what the people of Massachusetts through their elected officials have deemed a benefit they've earned and deserve. So just a friendly suggestion to those boards in those situations. So appreciate it. With that, I don't know, do Patrick or Natasha have anything else?
Thank you, everyone.
Thank you, everyone.
Thanks. This will be recorded, right? And this will be posted,
Yes.
and
Yes, it
the
will be posted.
presentation will be posted. So,
Yes.
all right. Thanks all.
The
Have a good rest of
handout
the
is
day.
already on the website if anyone missed the download in the chat. All right, take care. Have a great afternoon.